Slides are not designed necessarily for you to read during the presentation, but they are available via the DCA to download later, because I've cut and pasted elements of the Direct Marketing Guide from the ICO's booklet, very helpful booklet, to illustrate the points that I'm making. So the first thing that I'm going to talk about is simply that whilst everybody has heard about GDPR and talks about GDPR, a little known fact is that the Privacy and Electronic Communication Regulation of 2003 is still there. It was due to be replaced in 2018 by EU Electronic Marketing Directive, but it wasn't. And the reality is therefore that some things, in fact, quite a lot of things have stayed the same. So I'm going to talk a little bit more about that in detail, and it's more related to electronic marketing rather than traditional off the page or direct marketing. But next slide, please. So the first thing to say about PECA that isn't that well known is that my first learning and my first technique is really that B2B marketing is generally exempt. So if any of you, and I appreciate they'll be in the minority, they're actually targeting other businesses, then in reality, the rules and legislation related to GDPR and PECA in general about consent don't apply. Now, there are some specific things, as I've flagged here in paragraph 142 and 144 within the Direct Marketing Guide, but the specific things are that a corporate email address is actually an email address that's associated with an incorporated business. That means sole traders and some partnerships are still treated as personal data, which I appreciate is a pain for businesses to be able to try and differentiate between corporate entities and non-corporate entities. But that's just the way that the rules work. That said, there has been variance in the interpretation from the ICO, and that I have seen, and I have got a transcript from the ICO saying that any email address associated with a corporate company, i.e. the email address at and then the company name, is regarded as a corporate entity. So that's still up for discussion and hasn't been determined yet. But the principle is that you absolutely can send out emails without consent to corporate entities. And as I say, there are some personal records, but one of the biggest confusions that people have is they assume that, for example, Rob at m-i-g, which is my email address, is a personal email. It's only for me. But in reality, it's still a corporate entity. So even if it's a personalized name and it can only go to one person, then the fact remains that is a corporate email address and it can be emailed to without consent. So B2B, outbound cold emailing is quite legitimate. Now, that said, there are various different elements and techniques to use that I won't go into today, but just wanted to flag that first point. So next slide, please. Probably the biggest impact for most of the people that might be listening to this is the soft opt-in. And a lot of people don't understand the soft opt-in, but basically it says that you can use an email address that has been given to you during the course of a sale or a negotiation, as long as you're using it for the same purposes that it was submitted for, and you gave the person the opportunity of opting out. Now, that means that in the circumstances that you are trading online, then anybody that submits an email address into your platform, that email address can be added to your marketing file. And I'll just, the next two learning points really are to clarify that, because I've been finding as I've been working with a number of businesses that there's an awful lot of people who don't realize that that's the case. So the impact of that was shown on the next slide, please. So my learning two here is quite simply that emails captured as part of an abandoned basket process can be added to your marketing file. Now, most people that I'm coming across are using cookies to contact these people, but in reality, they can also be added into your overall marketing activity. As I say, it's a situation where the email has been given during the course of a sale or a negotiation, so quite clearly meets that definition. There might be an issue for some people about whether or not they offer people the opt-out, but all is not lost. I'll come on to that shortly. Learning 3 is that emails captured during a guest checkout, therefore, can also be used. Now, an awful lot of people that I seem to be coming into contact with think that guest checkout is another way of opting out. And the reality is it isn't. It's just that people want to get out of the process of purchasing as quickly as they can. And they perceive that guest checkout is the fastest exit route. So they select it. So if any of you out there have got guest checkout files that you're not currently using for marketing, then I think it's worth you just double checking the situation, because you might well be able to add a significant volume of email addresses to your general marketing file. Next slide, please. In the circumstances that you don't comply, i.e., just to remind you, the email was given during the course of a sale or a negotiation, well, you wouldn't have the email address unless they had done that. It's used for the same purposes. I'll come on to that in a second. But finally, an opt-out was given. One of the problems that people might have is that there isn't a situation where necessarily an opt-out was given. Now, one of the great things about GDPR and PECA is that there is a situation where nothing's cast in stone, and there is an opportunity to change things if you haven't got things right first time. So to be more specific, a data controller has got an absolute right to notify a data subject or subjects about any changes that they wish to make over time. So it can be fluid, and it's actually expected to be fluid. And the legislation and the rules and regs related to it are actually set up on that basis. So basically, if you've got data that you're not sure about, then I use a process called repermissioning. And I'll explain more about repermissioning shortly when I talk about some of the other learnings. But the basic rule, as I flagged on this slide, is no marketing. So a notification cannot carry anything in it that relates to marketing. So it has to be simply a factual communication. And that factual communication, as I say, could be clarifying the opt-out position of an individual or a data subject. There have been examples where people have been fined and caught out, and I remember Flybe in particular, during that heady time before 2018's May GDPR launch, when they invited people to resubscribe for marketing. And the communication itself was a notification. That's absolutely fine. But unfortunately, they included an invitation to get involved in a prize draw for all the people who responded. And that therefore is marketing, and that therefore was illegal, and they got fined 75,000 for doing that. So watchword is, of course, care, but absolutely no marketing. So next slide, please. So apologies for all of this. We'll be talking through paragraph 175, but I have extensively used repermissioning during the course of the last decade in reality, when I have been transferring databases from failed businesses into new businesses. So the Habitat database that now belongs to Sainsbury's, we sold to Home Retail Group when it was Argos and the DIY chain that's name has just escaped me. But we repermissioned all of that data. And in fact, we ended up selling to Home Retail Group more data than Habitat had been using. And we had a similar experience with HMV. HMV's marketing team thought that they'd only got 2 million email addresses that they could legitimately market to. But taking on board the things that I've just flagged to you in the previous slides, we actually managed to find over 11 million, 6 million of which we were able to successfully repermission. So when we relaunched HMV, we relaunched it with a database 3 times the size of the business that had failed, just to put it into context. And we've done it for many other businesses. And I get contacted by insolvency practitioners and agents pretty well every week. There's actually been 2 this week, and I produced a booklet a few years ago for insolvency practitioners and related businesses to explain to them more information about this, as the asset of data is something that can be sold on quite happily. Now, the point of paragraph 175 here is, if you have read the detail, and if you haven't, I'll just summarize, is that actually there is a capability and a facility within the rules to allow data to be sold on. In fact, the insolvency side of the ICO perceives that it can be done quite relatively easily without my process of repermissioning. And they've said in the past that they think I'm going over the top and being too cautious. So for all those people that don't realize that you can acquire data, then clearly this is a good route. And so far this week, I've been offered a homewares database and business assets, and a fashion house database and business assets. So these things are cropping up all of the time, and a lot of people don't know. In fact, the vast majority of people don't know. And the reason I get contacted is because obviously I've got connections into the insolvency sector, having worked in it. But then in addition, they realize that I'm quite well connected through people like yourselves as members of the DCA, and the opportunity of passing on and introducing opportunities to people as they become available. So next slide, please. So my final learning as such is list rental. And what surprises me when I'm working as a consultant with companies is that still I find there's an awful lot of them either don't list rent or stop list renting after GDPR, perceiving that their database of being used legally. And the reality is that, as I flagged here in the headline, I mean, 25 years ago, I was working in Vernon's Pools with 2 million subscribers, and we made £1 million a year effectively in round terms from renting out our data. Half of it came from renting out the data, and half of it came from a combination of introducing people to other products and services or insert streams. So I'm sure that you're all very familiar with insert streams, but for me, list rental is surprisingly underutilized, and I'm often coming across companies that are not currently using it. So clearly, in the circumstances that, and I wouldn't advocate for anybody to share or rent out email addresses, primarily because there is legislation in place that does require a third-party opt-in to enable that to happen. So that data is very rare. But more specifically and less intrusive and less of an impact is the ability to rent out data, which primarily is covered on the last point here through legitimate interest, which is part of GDPR and one of the legal bases for processing. So in other words, and I know that anybody that's part of the Abacus pool will recognise that this can be done. But for anybody that isn't involved in that, then clearly is another opportunity to generate additional revenue from an existing database. And nicely, I think in most cases, particularly often with the demographic that I'm working with, which sadly I'm now becoming part of, it's actually a pleasure now to receive catalogues and to flick through things. So there's a whole host and a whole opportunity out there. And I know that there'll be several people in the conference operating in this area and talking about it in detail. But I just wanted to flag it as part of the key points. So rather than compliance being an onerous thing, in actual fact, it can be a good thing. And when I worked in the pools industry and worked for Ladbrokes, I remember a director of the casino division, Mike Bennett. I was once complaining to him that I was having to struggle with gambling compliance, and he said, "No, never complain about compliance. We love compliance." And he said, if it wasn't for compliance, everybody would be doing what we do. And that's the reality. I think a bit of education, a bit of understanding, a bit of digging, and I would thoroughly recommend, if anybody hasn't read the direct marketing guide that the ICO produce, then go onto the ICO's website, search on direct marketing guide. It'll give you a click link to a PDF, or send me an email and I'll give you the link. And there are pages and pages of useful information, and it's quite helpful because they actually explain quite clearly the various points using examples. The thing to watch out for is there are boxes that are rather than greyed out, yellowed out or oranged out, and in those boxes where GDPR has made a change to the direct marketing guide, they flag it there. So there's an opportunity for you to very quickly and easily pick up that information. So last slide, and with just a few minutes left to go, I'll just summarize to remind you the points. And usually for me, I'm finishing early, but in reality, it's a nice, neat little subject that hopefully has been helpful for people. So say number one, and the one that the vast majority of my business is now involved in, is lead generation for B2B activity, which is say generally don't need consent, and generally the emails are available for use. I know that there's an awful lot of people don't realize that this is the case, because when I am sending out emails, I get an awful lot of emails back telling me that under GDPR rules this can't be done, and of course people just don't know about PECA and what can be done, but not a big issue. Secondly, and I hope this is really helpful for people, because I'm sure that there's an awful lot of data sitting around in businesses as abandoned baskets that's not been utilized, that could easily be found and utilized as required. And similarly, guest checkout data. Anybody that's using the Priam system, I think that defaults automatically to guest checkout being opted out of marketing. And therefore, I think you'll need to make some changes there. But hopefully that will release a chunk of data. Certainly, there was one business that I've been talking to recently that thinks that there's about 80,000 records in that section that they currently weren't marketing to and now can. So it could make quite a significant impact in most businesses. And then my tongue-in-cheek comment is, if in doubt, sort it out. And repermission your data. And there's no harm in repermissioning data over a period of time, or doing it periodically. But the important point here is to do it in such a way that you're not requiring an opt-in, because only 5% of the database will respond. Better to have an opt-out, and only 5% of the database will respond. And therefore 95% of the data via inertia will get taken along with whatever you're proposing. Customer data, as say in failed businesses, if you need any help, by all means contact me. But if you keep your eyes and ears to the ground about competitors or businesses that may fail, then invariably the people that are managing that failed business don't realize that the data asset is something that can be passed on to a third party. So hopefully that will introduce you to new marketing data to freshen up and add to what you've got. And then finally, the key point there about data rental. So thanks very much for listening. If there are any questions, I will be around all day. So by all means, try and find me or fire questions to me through the system, and I'll happily answer where I can.